Hello, dear students. It's very nice to see you. We continue the course of lectures on international criminal law. Today, we will talk about the first international criminal courts with the help of which, for the first time in the history, individuals were brought to international criminal responsibility about Nuremberg and Tokyo tribunals. Let's revise briefly how the international criminal justice gradually was appearing. Previous to the Nuremberg and Tokyo tribunals, there were attempts to hold individuals accountable for what today is considered an international crime. Following the end of the First World War, the Commission on Responsibility of Authors of the War was established by the Paris Peace Conference in 1919. There was proposing to set up an ad hoc tribunal to try persons responsible for war crimes. The offer was not implemented, but it was proposed to try Kaiser Wilhelm II before an international tribunal under the Peace of Versailles. The Kaiser fled to the Netherlands, his extradition was refused, he was recognized as a political fugitive. Also, under the terms of the Versailles Treaty, only 12 accused instead of 800 were actually brought to trial in Leipzig. In 1943 was signed the Moscow Declaration. The declaration stated that German war criminals would be returned to the countries in which the offenses had taken place, and they would be brought back to the scene of their crimes and judged on the spot by the peoples whom they have outraged. Following their victory in the Second World War, the Allied powers established international military tribunals in Nuremberg and Tokyo to try war criminals for German and Japanese forces. The creation of these tribunals represented the first proper expression of international criminal law and procedure. So, the International Military Tribunal at Nuremberg was established by the London Agreement of 8 August 1945 between the governments of Great Britain, the USSR, France, the United Soviet Socialist Republics. The London Agreement was signed by the 4 main allies and later 19 states joined it. The tribunal had 8 judges, 4 principal judges, 1 for each of the major allies, France, USSR, the United Kingdom, and the US, and 4 alternates from the same state. The president of the tribunal was from the United Kingdom. The defense was undertaken by a number of German lawyers. Let's consider the jurisdiction of the International Military Tribunal at Nuremberg, namely 4 types of the jurisdiction: subject matter jurisdiction, territorial jurisdiction, temporal jurisdiction, and personal jurisdiction. Subject matter jurisdiction, or jurisdiction ratione materia. The subject matter jurisdiction was set out under Article 6 of the Tribunal Charter, which provided the tribunal established by the agreement referred to in Article 1 hereof of the trial and punishment of the major war criminals of the European Axis countries, like Germany, Italy, and Japan, shall have the power to try and punish persons who, acting in interests of the European Axis countries, where as individuals or as a member of organizations committed any of the following crimes. Which crimes? Crimes against peace, war crimes, and crimes against humanity. Crimes against peace, namely planning, preparation, initiation, or waging of a war of aggression or a war of violation of international treaties, agreements, assurance, or participation in a common plan or conspiracy for the accomplishment of any of these acts. War crimes. According to war crimes, namely violations of the law or customs of war, such violations shall include, but not limited to, murder, ill treatment, deportation to slave labor, or for any other purpose of civilian population, or in occupied territory, murder or ill treatment of prisoners of war or persons on the seas, killing of hostages, plunder of public or private property, wanton destruction of cities, towns, village, or devastation not justified by military necessity. Next crime is crimes against humanity, namely murder, extermination, enslavement, deportation, and other inhuman acts committed against any civilian population before or during the war, or persecutions on political, racial, religious grounds in execution of or in connection with any crime within the jurisdiction of the tribunal, whether or not in violation of domestic law of the country were perpetrated. Leaders, organizers, instigators, and accomplices participating in the formulation or execution of a common plan or conspiracy to commit of any these crimes are responsible for all acts performed by any person in execution of such plan. There were some difficulties with justifying these classes of crimes during Nuremberg process. Why? Because the charter of the tribunal, firstly in history, established individual criminal responsibility for such crimes under international law. So it was problem to justify these crimes. Concerning justifying the existence of crimes against peace, Article 6a of the Charter provided for the prosecution of those who directed or participated in war of aggression against other nations in violation of treaties and the principles of international law. The inherent problem with formulation and the offense of crimes against peace was related with the prohibition of aggression. The tribunal in its judgment made reference to such instruments as 1928 General Treaty for Renunciation of War as an instrument of national policy, also known as the Kellogg-Briand Treaty. This treaty outlawed, that is prohibited, recourse to war, the waging of aggressive war, as well as certain methods of warfare were recognized unlawful. Germany was a party of this treaty. Also, tribunal was asserted that the crime of aggression have been established under customary law. Customary law existed before the tribunal. The next crime is crime against humanity. The Charter represents the first codification of crimes against humanity. Before the Nuremberg Charter, crimes against humanity existed in the moral sense. A quite difficult legal issue was whether crimes against humanity under Article 6 existed, because crimes against humanity were not a party of treaty law, and it was necessary for court to avoid breaches of the ex post facto principle. It had been common knowledge that atrocities against German Jews and minority groups had been carried out by the Nazi regime, as well as similar offenses against other civilians of other countries occupied by Germany. Whilst the brutality against civilians of other countries during the course of fighting or occupation might have been covered by already established international law on war crimes and aggressions, atrocities against states' own citizens were not. Article 6c of the Charter concerning crimes against humanity was drafted so as to encompass these acts which had occurred on such a massive scale they could not be ignored. Article 6c of the Charter covered acts against any civilian population, so including German population, not only population of other countries. Thus, the rationale for crimes against humanity was predicated on a theory of jurisdictional extension of war crimes. So it was applied theory of jurisdictional extension of war crimes. The reasoning was that because war crimes apply to certain protected persons, namely civilians, in time of war between belligerent states, crimes against humanity would merely extend the same prescriptions to the same category of protected person within a particular state, provided they are linked to the initiation and conduct of aggressive war or to war crimes. It was connection between all these crimes. Thus, the inclusion of crimes against humanity in the Nuremberg Charter was undoubtedly revolutionary. For the first time, international law reached crimes committed within rather than between sovereign states. Article 6 required a link between crimes against humanity and crimes against peace and war crimes. Linking crimes against humanity to the treaty-based war crimes and crimes against peace provided like a shield against charges that prosecution for these crimes violated the principle of legality, or principle nullum crime sine lege. We talked about this principle last lections. So war connection was necessary for the tribunal to adjudicate atrocities which would otherwise remain only internal state affairs. Next question is justifying the exercise of war crimes. From the perspective of the principles of legality, the easiest to define of this crime was war crimes. War crimes in Article 6 included customary law as identified inter alia by reference to the Hague Convention 1907 and conventional law as evidenced in the 1929 Geneva Convention relative to the treatment of prisoners of war. Thus, the legality of the concept of war crimes was unquestionable. Also, the defense argued that tribunal did not enjoy jurisdiction for violation of the laws or customs of law. This argument was correctly rejected on the basis that war crimes prosecutions against aliens had a long history in the law of nations. Thus, it was subject matter jurisdiction. War crimes, crimes against humanity. Now we will talk about territorial jurisdiction or jurisdiction rational laws. Territorial jurisdiction of the tribunal was designated by the formula for the trial of war criminals whose offenses have no particular geographical location. This formula emphasized the scope of criminal activity that went beyond the boundaries of individual states. The territorial jurisdiction of the tribunal included the territory of all states involved in armed conflict in Europe. Concerning temporal jurisdiction or jurisdiction ratione temporis, the competence ratione temporis is not provided by charter of the tribunal, but it closely linked to the start of World War II and the period in which it took place. The temporal jurisdiction of the Nuremberg Tribunal extended to action that occurred in the past and were directly related to events of the World War II. The competence ratione temporis is laid down in the period before or during World War II. Next type of jurisdiction, jurisdiction ratione persona. The tribunal asserted crimes against international law are committed by men, not abstract entities, and only by punishing individuals who commit such crimes can the provision of international law be enforced. Individuals have international duties which transcend the national obligation of obedience imposed by the individual state. Thus, crimes against international law are committed by individuals, not abstract entities, and only by punishing the perpetrators of such crimes international law can be enforced. The tribunal established for the trial and punishment of the major war criminals of the European Axis countries shall have the power to try and punish persons who, acting in interest of the European Axis countries, whether as individual or as a member of organization. Concerning official position of the defendant, their official position, where as a head of a state or responsible officials in government department, shall not be considered as freeing them from responsibility or mitigating punishment. The fact that the defendant acted pursuant to order of this government or of a superior shall not free him from responsibility, but may be considered in mitigation of punishment if the tribunal determines that justice so requires. Leaders, organizers, instigators, and accomplices participating in the formulation or execution of a common plan or conspiracy to commit any of the international crimes enshrined in statute are responsible for all acts performed by any persons in execution of such plan. The judgment of the International Military Tribunal at Nuremberg was delivered on 30 September 1946 and sentences were pronounced in 1st of October 1946. The trial took place over 10 months and 400 open sessions. The tribunal indicted only 24 persons, of whom 22 were prosecuted. 12 of the accused were sentenced to the death through hanging. 7 were sentenced to imprisonment for terms ranging from 10 years to life. From them, 3 were actually sentenced to life imprisonment. 3 of the defendants were acquitted. Of the 6 accused organizations, only 3 were found to be criminal. The legal basis and criticism of International Military Tribunal. This is the next our question. The International Tribunal is commonly regarded as the first international criminal tribunal of its type. However, it can be argued that the tribunal was not so much an international tribunal, but rather an allied forces tribunal. Such rights of these countries have been recognized by the other countries. The International Tribunal was criticized for the following reasons: insufficient procedural safeguards for the accused. Next, applying ex post facto law, thereby violating the nullum crimen sine lege principle. Also, it was provision about the trials where victors' justice. Let's consider these arguments. There were insufficient procedural safeguards for the accused. Indeed, some aspects of the Nuremberg trial were imperfect. Article 16d of the Nuremberg Charter gave the defendants the right to legal representation, but in fact, the defendants met with their lawyers only immediately before or even on the first day of the trials. For example, there was a huge gap in resources between the prosecution and the defense. However, given the standards applicable to trial at that time, the proceedings were basically fairly run. There has been a persistent critique that International Military Tribunal in Nuremberg applied ex post facto law, thereby violating the nullum crimen sine lege principle. Defense argued that it was unfair to indict Nazi leaders for violations laws that had not yet existed at the time they committed the acts of which they were accused. This is called ex post facto justice. In particular, it was affirmed that aggression did not entail individual criminal responsibility in international law before World War II and thus constituted ex post facto law creation. And the defense insists that the prosecution of crimes against peace was contrary to the nullum crimen sine lega principle. The tribunal rejected, of course, the nullum crimen sine lega objection based on the following arguments. Firstly, it held that the court was bound by the statute of the tribunal. Tribunal stated that its charter was binding upon the tribunal as the law to be applied to the case. And secondly, that the charter did not violate the principle of legality as it was a declaration of international law